Let me just ask one more question here because I want to get to questions from the audience, and I haven't picked on Sean yet. So it's been said the 2005 Detainee Treatment Act legislatively formalized and sanctioned the establishment of a dual standard of treatment, with the military having a more restricted standard and the CIA being given broader reign. We've already talked a little bit about this, but you want to pick up on whether that makes any sense in law or policy? Or if you'd rather defer to David, he wrote the question, so you can stick him with it.
No, I think his response, I'm sorry. It seems his response spoke to that issue of these dual standards being unworkable. And you know, there's a microcosm of these dual standards, of course, in the Department of Defense. One of the surprising legal determinations about the conflict in Afghanistan was the choice to parse it into two conflicts, to determine that there was a conflict against Al-Qaeda, there was a conflict against the Taliban, and that these were separate, and that where the Taliban, the conflict with the Taliban, in the President's estimation on 7 February, was sufficient to trigger the Geneva Conventions, if it wouldn't apply in an individual sense to any of those Taliban fighters later, at least it had triggered the convention. Well, the Al-Qaeda had managed not to trigger the full body of the Geneva Conventions, and moreover, through, again, I was alluding to this earlier, very clever legal analysis, if wholly inconsistent with the traditions of the law of war, they managed to find a way around the application of Common Article 3 as well. But there again, we have this dual standard, this idea that soldiers operating in a common theater of operations are to apply two different standards to two different sets of enemies that they encounter on the battlefield. And so if it's unworkable within the government writ large, imagine how complex that can be within a single theater of operations as well.
All right, well, it's time to go to the audience. Before we do, just I've been looking out and seeing all the green uniforms out there, and perhaps some non-green uniforms too. We've missed Veterans Day by a few days, but I hope you'll join me in saying thanks for your service to all the people, both in uniform and those who served. And now my iPhone says we have 2 seconds. Now we have 15 minutes left for questions. Why don't you wait for the microphone? Who's got the microphone? That's the deciding thing. All right, your question. Please address it to one of the members or to the panel in general.
All right, this refers to a comment made by Mr. Watts, and he talked about how some of these memos make a compelling case, make a lawyerly case for some of the policy choices. My observation, I'd like to get your thoughts on it, is that where these attorneys went wrong is in fundamentally misunderstanding their role in Office of Legal Counsel, in that they were not serving as counselors, they were not serving as advisors, but rather they had become advocates. Where the role of a counselor or an advisor is to advise on what the law is, and the role of an advocate is to advocate a position and to change the law. And I think that, what are your thoughts about that?
I would agree. I mean, I think lawyers should have a holistic sense of what's good for the client. And so often the best advice I gave commanders was not legal at all. Oftentimes the proposed action or the plan that I was reviewing was entirely legal, but it was a bad idea from another perspective. And part of the training in Charlottesville is to remind lawyers of that utility. That look, you're capable of being slightly more objective than other members of the staff. By no means are you smarter than anyone else on the staff, but you do come at problems by virtue of your legal training from a different angle, and lawyers are reminded of that. Now, just to play devil's advocate, imagine though that what I suggested earlier was true, that their goal, if you take them as lawyers and they have clients, and their client is the president or their client is the Secretary of Defense, their goal is to keep him out of jail. If your goal is to keep him out of jail and you're staring the War Crimes Act in the face, that's my point. They did make a colorable argument on a few of these points. Now, I still don't think it's safe to travel internationally. I think a lot of these are unreasonable arguments viewed from external sources. And so, yes, I would agree that they fell short of their role as counselors. Perhaps they were just being too narrow. I don't think you can underestimate the role that this War Crimes Act played in their analyses.
But if I could just follow up, I mean, were they asking the...
If you have the microphone still?
Were they answering the question, can we do this, or what is legal to do? Or were they answering the question, how can we do this? Find us a way to do this.
Yeah, is this result-driven legal analysis? Absolutely, it is. Professor Sand's investigative work, I think, shows that. That's also apparent on these memos. But look, they didn't have a monopoly on that approach to legal thought. Spend enough time in the government and you become painfully familiar with result-driven legal analysis. How often, as lawyers, have any of us had the opportunity of saying, I'm just curious, Jack, tell me what you think we ought to do, or what would the law tell me to do? That's not the question that's posed. The question that's posed is, we're doing this. Is it legal? Can we do this in a way that is consistent with the law? And the JAG's job, in most cases, is to work as hard as she can to get to yes, but then ultimately to make the very difficult call that uniformed lawyers ultimately did. When they run up against that line, when they get to know to be very clear about that. That's where these gentlemen, for the most part, failed.
Sean, just one quick or two quick observations. One, the mission is not just to keep the lawyer out of jail. The mission also is to help the lawyer win the war, to help the client win the war. And, the lives are at stake and so forth. So the desire to try to find a legal solution to get the information they thought would save American lives is a real one. The only other thing you said that you often give policy advice, and I've always, when I was in government, I would often say what you're suggesting is legal. I think it's a mistake because of this. The one thing that I think is unforgivable is to decide it's bad policy and tell them it's illegal when it's not. That's the one thing that's unforgivable. But to me, the job of the lawyer is not just to give legal advice, but also, if he thinks the decision maker has overlooked something, to very respectfully say, General, Mr. Secretary, whatever, have you considered this? And I've never gotten a negative reaction from doing that. They don't always take my advice, but they always seem to appreciate it.